no. If it's no, that's fine. We'll come and we'll have a trial if you want to do that. If it's yes, then we can probably
I just
make a plea.
said yeah, nigga. I just said yeah, man. Move it on. I just said yeah.
So, making.
What's good, YouTube fam? Welcome back to Dog Eat Dog Court. This is a little bit different. I've been wanting to add my voice onto the videos, and I figured this is the perfect time. I'm gonna play this video in a second, but I thought that this is hilarious how these guys are sitting here communicating with each other through the Zoom before the judge jumps on. Hilarious, but yeah, guys, enjoy.
All right, start this. Yes, we call the case of People v. Joshua Ford. Percent. So we have Mr. Hardy.
Yeah, y'all can hear me.
Great. So this is going to be case number 24S19158 FH People v. Hardy. Mr. Hardy is present via Zoom. This is date and time for status conference. The offer is what it has been. The offer to the defendant plead guilty is charged with dismissed individual second or killed with cap in the middle of the guidelines. PSI, fines, cost restitution, and any time would be consecutive to the time is currently served.
All right, Mr. Lewis.
Mr. Hardy, can you hear me okay?
Yeah, I can hear you.
All right. The offer was the middle of the guidelines, and I have your guidelines tentatively pegged at about 10 to 23. I think the middle, of course, my math is correct, about 17 months. You asked me for a Cobb's. I approached the bench. I talked to the judge, and the judge indicated that he would do a Cobb's on the Killebrew grain, which means he would cap at the middle of the guidelines. Would that be correct, Your Honor?
Correct.
So basically, you couldn't get more than 17 months. Obviously, at the end of the day, when I'm advocating for you, I'm going to be looking to the bottom end at least. All right. So you asked me for a Cobb's, and you've got the Cobb's. The judge indicates he was going to not exceed the middle of the guidelines, which I tentatively are pegging them at 17 months. So you want to think about that and come back in a couple weeks?
Man, it ain't no, y'all can't go no lower, like 12 months, 15 months. It ain't no lower. Bro, this case ain't that serious, bro. This case not that serious.
What do you want to do, Mr. Hardy? Do you want to enter a plea, or do you want to adjourn this and think about this for 2 weeks?
Man, yeah, I'm gonna take the 17 months. That's the lowest y'all can do. I'll take the 17 months.
So you want to take the offer?
Man, yeah, bro, yeah.
All right. So, Mr. Hardy, if you want to do that, I need you to raise your right hand so I can have you sworn. You raise your right hand. You solemnly swear from the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Hold on, you said what?
You solemnly swear to tell the truth.
Yeah,
All right, you can put your hand down. So, Mr. Hardy, the charge, as Mr. Lewis just said, is assault of a prison employee. It's a 5-year felony and/or a $2,500 fine. Do you understand the nature of that charge and the maximum penalty?
Yeah, I understand.
Okay, do you understand if you go forward with this agreement that has been worked out on your behalf, you won't have a trial of any kind. So do you want to waive your right to have a trial in order to take advantage of what was just placed right on the record here?
I'm saying, Judge, you can't come down no lower. Like, you really feel as if 17 months was really the lowest you could do, bro.
Yeah. So Mr. Hardy, I already talked to your attorney. I'm comfortable with the idea of middle of the guidelines. I know nothing about this case, sir. I know nothing. So I'm not going to go out on a limb and say that it could be less. Mr. Lewis just told you he can argue for less, and once the court knows all the facts of it, maybe that makes sense. But until I know what occurred, I'm not going to agree to anything like that. So worst case, it's middle. Mr. Lewis you can argue the same thing for less, and then we'll see what happens.
17 months. Hey, no, I don't. All right, I understand clearly, right? Okay, no, I don't. No, I'm gonna let you do your investigation and something like that. I'm gonna wait to see if you. I don't want to take that 17 months.
Well, that's fine. You don't have to enter a plea, but that's not how it works. The court doesn't get the report and then you get to decide what the offer will be. You either have to accept the offer today, plea is charged without the habitual, with the idea the court will give you the cobs of 17 months. If you don't want to do this, then you'll come back at a later date and time and you can take the next step in the case, but that doesn't mean the offer would still be open. You might have to plead to a habitual offender then, and then the guidelines are going to be much higher.
All right, come on, man. Y'all piece. All right, come on, man. Come on. I'll take the 17 months, bro. Y'all making this shit more complicated than what it gotta be, bro. Come on.
All right.
I'm gonna take the 17 months.
Back to the plea taking process then. So are you waiving your right to have a trial in order to take advantage of this offer that's been made this morning?
Man, yeah, bro.
All right. Now, Mr. Hardy, if you were going to have a trial, you have all of these rights that I have to describe to you. So just bear with me, okay? At trial, you'd have the right to be presumed innocent. At trial, you could confront any witnesses called against you. At trial, you could call your own witnesses. At trial, you could testify, or you didn't have to testify. You don't have to testify, and that can't be used against you. At trial, you'd have Mr. Lewis if you wanted to have a trial. So you'd have the right to have an attorney at a trial. Are you waiving all those rights you'd have at trial, again, to take advantage of the offer that was placed on the record this morning?
Man, yeah.
All right.
Yeah.
Now, Mr. Hardy, two more things that we got to talk about. This one is, if you enter this plea, you will waive the right to come back at a later date and time and say it wasn't your choice to enter a plea. So in other words, you can't come back 6 weeks from now, 6 months from now and say, you know what, it wasn't my choice to enter a plea here this morning on October 29th. It was Mr. Lewis's choice, or it was that officer I was talking to off camera. All right. Do you understand that if you go forward, you can't come back later and say it wasn't my choice? You understand that?
Bro, yeah, I know all of this.
All right, well, I still got to say it. I still got to go through this so we can take this plea. So the next thing is, do you understand that if you go forward with your plea, you can't come back at a later date and time and say there were other promises or other threats or other inducements to you. For in other words, you can't come back in 6 weeks or 6 months and say, hey, wait a minute, they promised me steak dinners every Friday if I entered this plea. Something like that. You understand that?
Yeah, man. Yeah.
All right. So, Mr. Hardy, even with your plea, you'll still have a form of appellate review available to you. That's called leave to appeal. And with that, you could hire an attorney. If you couldn't afford one, you could request one from the court. Do you understand that?
Yeah.
All right. Let's talk about the charge. How do you plead to the charge of assault of a prison employee? How do you plead?
I plead guilty.
All right. The information says this occurred on or about May 21st of this year in the township of Easton, county of Ionia. Is that the correct date and location?
I guess, yeah.
Okay. And on that date and location, can you tell me what you did to assault Officer Ball? My understanding, you threw some kind of liquid on him. Maybe?
I didn't assault Officer Ball.
And how did you do that?
I didn't assault Officer Ball. What are you talking about? Hey, what are you talking about?
Well, if you didn't assault anybody, then We don't have a plea. Mr. Lewis, you want to help me out?
Mr. Hardy, did you in fact throw some liquid on the officer?
No, I didn't. Man, yeah, bro, y'all.
I guess, did you or did you not throw some liquid on the officer?
Man, y'all.
So is that a yes or a no? If it's no, that's fine. We'll come and we'll have a trial if you want to do that. If it's yes, then we
Bro,
can probably
I just
take a plea.
said, yeah, nigga. I just said, yeah, man, move it on. I just said, yeah.
So making obvious, somewhat incomprehensible, I guess is the word I'm searching for, noises doesn't mean it's yes. So you did assault him, you did throw some liquid on the officer, is that correct?
Man, yes.
All right.
Yes, move on.
Well, we got to have a definitive answer, Mr. Hardy. So, Mr. Hardy, well, let me ask this. Anybody want anything else on the facts, Mr. Butler or Mr. Lewis?
No.
All right. Mr. Hardy, back to you. Other than what we have spoke about this morning, has anyone else promised you, threatened you, or done anything to you to get you to enter this plea this morning?
Man, no.
All right, and then other than what we have talked about this morning, has anyone besides Mr. Lewis, because he's your attorney, but has anyone else said anything about what your sentence will be as a result of entering this plea?
Man, no.
All right, Mr. Butler, you aware of any other promises, threats, or inducements?
None.
Mr. Lewis, how about you?
None.
And Mr. Butler's the court complied with the court rule for taking the plea.
Yes.
And Mr. Lewis?
Yes.
Mr. Hardy, I have one last question. Do you want the court to accept your plea to assault of a prison employee?
Y'all.
I'm sorry, sir. I didn't catch that. Was that a yes?
I said, yeah.
All right. I will accept your plea. You did offer your plea freely, accurately, and voluntarily. So, Mr. Hardy, here's what's going to happen next. Somebody from probation will contact you to begin the process of completing a pre-sentence report. Mr. Lewis will have the ability to participate in that with you if you want him to. If you don't want him to, he doesn't have to. All right, that's up to you. Once that's done, we'll get you back for circuit court sentencing. That'll be about 4 weeks from now. All right. Mr. Hardy, you are all set today. You got an officer there with you. You are free to sign off on your end. Okay.
All right, man.
So it looks like everybody in this county jail knows each other. I think this is Iona. I'm in Metro Detroit right now, but this looks like Iona, I believe. But yeah, man, if you're still here, appreciate you. Like, share, subscribe. Catch you on the next one. Thanks.